With all this wonderful technology that's out on the marketplace now, are we overlooking something that's very fundamental? And that is, if the clients that we're going to serve, we're not meeting what the marketplace is demanding, then is all the technology irrelevant? Julie McFarland said, to the public, lawyers are associated with conflict, not conflict resolution. This happened to her when she was doing a speaking engagement like this. She was in the elevator in a hotel in Canada, and somebody asked her what she was doing there, and she said, I'm here to talk about conflict resolution. I'm a lawyer. And they said, that's odd. We think of lawyers as conflict makers. This book, The New Lawyer, is something that she wrote several years ago, and I think it's the Bible that all of us in law schools, and once we're even out, need to start reading. She said there's a growing realization among lawyers that they're in danger of rendering themselves irrelevant to ordinary people. We're seeing that more and more. In California, there's 70% of pro ses. That's riveting. Disillusionment with the traditional warrior mentality has motivated some lawyers to initiate new ways of practicing law that reflect a desire, both philosophical and pragmatic, to bring peace and resolution rather than protracted court battles. She says the new lawyer understands that not every conflict is really about rights and entitlements, and that there are conventional disguises for anger, hurt feelings, and struggles over scarce resources. I think we're seeing that more and more. The Harvard Negotiation Project tells a story about the orange. And if you think about the peanut butter sandwich story, if you have parents that have a peanut butter sandwich and kids are fighting over it, what would you do? You'd cut it in half or have a kid cut it in half. Getting to Yes says that if you have an orange like that, if you know the right questions to ask and you can find out why the kids want it, one possibly for a chef's class to use the rind for an icing on a cake, the other for the rind, you've effectively doubled your orange. You've effectively expanded your pie. This is Socrates. He's on here because the answer comes from knowing how to ask the right questions. My co-presenter this morning said, this is the bastard that gave all of us post-traumatic stress syndrome in law school, so we need to know at least what he looks like. This picture of an ear reminds us, as a metaphor, our primary job is to listen. And if we listen, we will understand what people's interests are. If we dig further into what their interests are, we can help them effectively create the solution to their problems that will not render us irrelevant. But back to the earlier slide, we'll get into their feelings and their emotions and what they need. The power of a positive no takes this one step further. Not just how to get yes by knowing what the other side wants and their interests are, but if you can't say yes, can you say, no, I can't do that, but I could do this, and keep the negotiations moving. The lawyers of the 21st century must find other ways to meet their clients' best aspirations, the achievement of effective, appropriate, and sustainable outcomes within a reasonable time frame, rather than years tied up in legal procedures and protracted litigation. Julie McFarland says we should be conflict resolution advocates. We should develop the best outcome, which is often settlement, and use interest-based negotiation for effective communication, relationship building, and persuasion. Interest-based is harder than position-based, but it's a tool we all must have to keep up with the marketplace. Zealous advocacy, do we leave that at the door? No, we don't. What we do is we educate the clients, give them the information to empower them on all levels, and then we let go. Something that's totally foreign to most lawyers. It's our case. We're controlling the case. We're the ones that know what to do with it. Counterintuitive to let go. And if we can, the world becomes our oyster. Come to find out, this is what the Walt Disney Corporation has done for 60 plus years. They do their option development, they evaluate their options, and those Imagineers come up with ideas that change our world. Disney World is a model for this. 3D negotiation was written by a professor at Harvard Business School, David Lax. He says, tactics plus deal design plus setup equal remarkable agreements that are unattainable by standard tactics. Client satisfaction is something we can't forget about even with technology. If the parties are involved in building this agreement by synthesis, then they're creating options, evaluating the options, negotiating the options, and then they own the solutions, which are more acceptable and more durable. And in the end, that's what we need. The signs are clear and incontrovertible, says Julie McFarland. Change is coming. Change is needed. Can we be on board on that train?